Welcome. I'm Ed Rock, Director of the Institute for Corporate Governance and Finance. And on behalf of Jennifer Arlen, myself, welcome to really our first program of the year. It's very early in the year. And this is a program that is organized by our two centers, Jennifer's program on corporate compliance and enforcement, as well as the Pollack Center. And I see David Yermak, co-director of the Pollack Center here. And welcome to our panelists, and welcome especially to, is this on? Welcome especially to Rob Jackson, my newest colleague here on the NYU Law faculty, having just switched over from Columbia, and as you know, nominated to the commission, so with the advice and consent of the Senate, I hope you're new. Let me briefly introduce the panel. You have the brochure, so you have all of their biographical details. But I want you to know who you're going to be listening to. You know, to my immediate right is Jay Clayton, who you all know is the chair of the commission. Stephanie Avakian and Steve Paikin are the co-directors of the Division of Enforcement, and Peter Driscoll is the acting director of the Office of Compliance. It's a particular pleasure for me to have Jay Clayton here because it's always wonderful to see a former student go on to such a high degree of success. We were both a lot younger when Jay was in my antitrust class years ago at Penn Law School. He's gone on, as you all know, to a spectacular career, a leading partner at Sullivan & Cromwell and now at the Commission. But what you may not know is that he co-taught for many years an M&A class at Penn with Joe Gatto and Joe Frumkin, which, but for the fact that I figured out a way to make it complementary with my M&A class, would have been competitive and would have left me in the dust without any students. So together we figured out a way to have the students take both, but he was spectacularly successful and an enormously popular teacher among the students in the years, the 8 or 9 years or so that Jay taught that course. But now it seems to be too busy to do it. Let's open with a few remarks from Jay, and then we're going to go to a panel discussion. Jay?
Well, thank you, and I'll call you Professor Rock. And thanks to NYU and Jennifer for inviting us. And I actually feel very comfortable in the student forum, and I know we're going to get to questions and answers, and I'm looking forward to that because I found during my teaching days that I learned a lot more from the students than they probably learned from me. And given the people in this room and the experience that this is in this room, we may learn more from you. And I look forward to your questions. I see a number of people who had the jobs that we currently have before, and it's nice to see them here today. I think you asked me to say a few words in the area of enforcement and compliance and how I see the commission. And I say it's early days. I get to use that excuse for a while longer. But a couple of things that I just want to point out. One, and I mention this about everywhere I go, the quality of the people at the commission, and that doesn't include Steve because he's new. But Pete and Stephanie and the others in the enforcement division and NOC have welcomed me and educated me and made me very comfortable with the work they do. That's a nice segue into where are we going from an enforcement perspective, and I'm not going to step on Stephanie or Steve's territory, other than to say that I'm very comfortable with the approach of the staff to our job in this regard. Times change, markets change, different philosophies. And there's some things that are of particular interest to me. I've made those clear. I think that individual accountability is something that is extremely important. I come at this from the perspective that it's a privilege to work in the securities industry. The securities industry has rewarded many people who work in it. It's an important industry that links our industrial sector to the everyday investor. And people should behave. And if they don't behave, it is important, and it's important to focus on individual accountability. And it's a privilege, and I think that we should recognize that in the way we pursue enforcement. So that's individual accountability, and I'm happy to talk more about that. The other area that's important to me and is a new development, I know it's been on Pete's radar screen for some time, Stephanie as well, and Steve and I looked at these issues in the private sector is cybersecurity and cybercrime, and the enablement of cyber violations, cyber fraud by new technologies. It's an area that I believe needs focus on several levels. I'll briefly talk about that, but we can talk more about it in Q&A. On the disclosure level, and I don't mean this in the sense of if your disclosure is less than perfect that you should have liability. I mean this in the sense that I'm not comfortable that the American investing public understands the substantial risks that we face systemically from cyber issues, and I'd like to see better disclosure around that. And then secondly, at the sort of market abuse level, and some of the things that you see in the initial coin offering space and areas like that are of particular interest to me. With that, as some opening remarks, may I turn it back to Jennifer? I think you'll take us forward.
Thank you very much. So, echoing what you said, and in prior remarks, you talked about the importance of focusing enforcement actions on the retail investor, on concerns of Mr. and Mrs. 401k, and in particular, actions aimed at unscrupulous people who sell worthless securities to retail investors. And these scams obviously impose genuine costs. On the other hand, so do materially misleading statements and FCPA violations by multinationals. So I'm interested in a world of limited resources where more focus on one side inevitably will mean less on another. Is this new focus going to lead to less enforcement actions in the materially misleading statement space and FCPA, or some other adjustment to all of the three of you?
I mean, I'll start off. I think, actually, before I get started, let me, just on behalf of all of us, sort of give the standard disclaimer that the remarks we give tonight are our own and do not necessarily reflect the views of the Commission or the Commission staff. You okay with that?
It's really good to have good lawyers.
And so with that, look, I wouldn't expect to see any pendulum swing. But I do think it's fair to say we are very focused on retail investors and things that affect retail investors, as I think the Commission's always been. But you know, when we say we're more vigilant about protecting Main Street investors, I think you know, it's pretty simple. These are often our most vulnerable, often our most unsophisticated market participants, and so they deserve a really focused level of protection. But I really wouldn't expect to see a large pendulum shift. And I also don't really think there's as strict of a trade-off as folks think about. I mean, fraud is always bad for investors. So when we think about it in terms of whether it's disclosure fraud or whether it's some other kind of misconduct, it all affects retail investors in different ways. And I also wouldn't make the mistake of thinking about it solely in the context of microcap fraud or Ponzi schemes. I mean, you can think about things that affect retail investors in lots of different ways. And so you can think about the sale of structured products to retail investors without appropriate disclosures, hidden fees, share class issues. I mean, I could think of all kinds of things that directly affect retail investors and that I would not put in the the sort of bucket shop space. And so I think we think about it fairly broadly.
Yeah, I mean, having returned to government for the first time in 15 years and really been focused for most of that time on Wall Street type cases instead of Main Street type cases, I would say one thing that struck me very hard is the amount of just dramatic, purposeful, intentional misconduct and fraud that makes up the steady diet of the commission's work. And so you come into this job and you may have your own priorities, but there is an ever-ceasing flow of real misconduct, Ponzi schemes, offering frauds, rip-offs, and everybody from wherever part of the political spectrum or wherever they are, they're going to prosecute those cases. And so that's the vast majority of, I think, what consumes, our business. And, we can then, discuss where around, what are we going to do with the rest of that 20%. So I think you're going to see in the main, as history shows, less, really less differences between the work of any particular commission. And I think that's likely to be true of what lies ahead in the next few years.
If I could just follow up on that. I'm looking at David Yermak here as chair of the finance department, and I think David would probably be of the view that individual investors, the Mr. and Mrs. 401k, have absolutely no business picking individual stocks and should be invested in broad gauge mutual funds in index funds. Is there a place for the SEC in assuming that is David's view, assuming that's the view of the finance community, in pushing investors away from the sort of investments that make them vulnerable to that sort of fraud and towards collective investment vehicles?
Well, I'm not sure that I'm qualified to be an investment advisor, but we have a system. Our system is based on disclosure and education, not paternalism, right? So the professor may well be right that for most people, those are more appropriate and suitable investments. But, we live in a free country, and, our job is not to dictate, how investors allocate capital. So, that's sort of my view on this. Whether investors would be better suited to be in a broad, band index fund, that's fair debate, but, that doesn't mean that we shouldn't be policing the market for, investors in individual securities.
There's a long distance between index funds, and there are different types of index funds. There's a long distance between what I would say are broad-based, well-understood index funds and people who are doing self-directed IRAs in promissory notes that may or may not have anything backing them. And we see a lot at that end of the spectrum, and we see too much of it. And we see too much of it in an era where people have access to the internet, have the ability to check out who they're dealing with. And part of what we're trying to do is help Mr. and Ms. 401k do some of that research on who they're dealing with. If you move into the registered investment advisor world, the broker-dealer world, you're eliminating a substantial portion of that type of fraud. In fact, probably much more harm than picking a actively managed fund versus an index fund, no matter how you run the numbers.
So I also had a follow-up. In thinking about your priorities and the focus between Mr. and Mrs. 401k, I shared Ed's thoughts on the index fund versus going after larger companies and also FCPA, which is part of it. And I know there isn't necessarily a trade-off, but inevitably there will be some trade-offs. I was wondering to what degree has the rise of international enforcement by other countries in the FCPA space entered into the calculus of, it used to be the SEC and the DOJ were the main players in that area, and now there are other players who are taking a very active role.
Yeah, I mean, I think that's, in large part by the work of, our predecessors who have led the international community to more vigorous anti-corruption enforcement. Look, I mean, for people who are wondering whether the FCPA program is going to continue into the future, it's pretty simple. It's going to. There is a dedicated group of investigators at the SEC and at the Department of Justice and increasingly in countries around the world who are focused on this issue. The chairman spoke earlier at the Economic Club this year talking about the importance of anti-corruption enforcement and the dangers that come from corrupt behavior. So, I think the FCPA program is going to continue. You're going to continue to see, vigorous investigations and enforcement of that statute.
I'll just echo Steve's comments, and thanks to a number of the people in this audience, our pursuit of international corruption is no longer a unilateral exercise, which changes the dynamic substantially.
One last question relating to enforcement before we turn to Peter. In the last little while, the SEC Enforcement Division has focused on a number of issues related to enforcement, individual liability, which you've already talked about, and my favorite topic, which is incentives to induce self-reporting. And the SEC brought in DPAs and NPAs, and Andrew Seresny, who's here, had a speech saying those would be reserved for firms that self-reported. And I'm wondering if we can expect a similar approach to both individual liability and self-reporting going forward.
I mean, taking them in turn, certainly on individual liability, I think you can expect a similar approach in the sense that, as the chairman said in his opening remarks, we're incredibly focused on individual liability. We always have been. I think roughly over the last 5+ years or so, more than 70% of our cases involve charges against individuals, and we expect that to continue. And frankly, that's a critical focus of ours, in large part because individual liability and holding individuals accountable really is among the most, if not the most effective deterrent. And so we've got a strong record, but we're quite focused on continuing that. In terms of self-reporting, do you want to?
Yeah, I mean, I think self-reporting remains an important factor in an assessment of corporate cooperation and how a company has responded to a problem. You can read the CBORD report that articulates the factors that we have assessed and will continue to assess in deciding what credit and how to assess a company's response to discovery and our identification of an issue or problem. And self-reporting is obviously an important part of that, and one that I think will continue to have prominence in our evaluation of how to resolve or charge matters against institutions.
Would you continue the practice that no DPAs and NPAs if you don't self-report?
Well, Andrew, can speak for himself, but I think what he was limiting his discussions to the FCPA context. And so I don't know that he's articulated, and whatever he said is not binding on us, but you're so 2016, Andrew. So I'm not sure that we're articulating any broad gating issues, but obviously a difficult, and I've been on the other side of the table for this, whether to bring something to the commission's attention or to law enforcement's attention is obviously a very difficult decision, but one that when corporations step up and do it is one that I think has to, weigh very seriously in the decision about what kind of credit or benefit to afford.
I think that's right. The one thing I'd add to that is as we think about cooperation and how to assess it in any given case, we really are looking at the total package. Self-reporting is absolutely critical. But there are times when a company doesn't have the opportunity to self-report for a variety of reasons. They didn't know about the conduct, someone came to us first, or any number of reasons. And it really is critical, I think, for companies to be thinking about all of it. And we really are looking at all of it, including cooperation with the staff throughout the investigation, but also how did the company respond to this when they did learn about it? What did the audit committee do? What did the board do? What was done in terms of remediation? It really is the entire package, and we really are trying to look at each case individually and think about what is the right remedy here. And we're, also cognizant that folks here in this audience and elsewhere are really looking closely at that and analyzing how we treat those cases. We're going to try to be thoughtful in how we message that.
I want to try to drill down a little bit. We have a lot of students in the room who are familiar in a sense with the SEC and completely unfamiliar with it. And in particular, I think for many people who have never been to your office in DC connected to Union Station and seen how long the hallways are, the sheer scale of the SEC is a daunting scale. So as sort of a way of filling in some of the knowledge gaps here, can you just talk a little bit about, in enforcement and in compliance, just the scale of your operation and how you organize things to do your jobs? And then to the extent that there's going to be any shift in terms of a new priority on looking after the interests of retail investors, how does that shift how you go about doing your jobs?
Let me do the two things in that regard. The first is to talk about the scale of the SEC versus the scale of the environment that we regulate. While the numbers sound large, 4,500 people, a $1.602 billion budget, when you compare it to the scope of transactions and activities that the SEC regulates, I'm actually astonished at how much those people are able to cover. Now, the enforcement and examination division is roughly half the size of the overall SEC, so you're talking, around 2,200 people, more or less, and probably half the budget and less than half the IT budget. Think about that as compared to just one or two large financial institutions that are U.S.-based, not just financial institutions around the world that have, 100,000 people and an annual IT budget that is 6 times the IT budget of the commission. So what we cover is really quite amazing. On this shift, I want to make one thing very clear. There's not some dramatic shift in priorities at the SEC. I'm a very I don't know. I'm a picture person, Ed. You probably remember this from graphs I draw on the board and things like that. And perspective is important to me. And when I talk about Mr. and Ms. 401k, it's not not shifting everything to what transactions are they engaged in or not. It's more, and I don't think this is new to the commission. I think it's been there for a while. How would they want us to spend our time? They want market integrity. They want to know that high-frequency traders are not, adversely affecting the way the marketplace functions. They want to know that, there's not public corruption or public corruption offshore conducted by U.S. registrants. They want to know these things. And when you talk to the men and women of the commission, particularly the career staff, that's the way they look at the world. And I think it's the right way to look at the world. So let me, preface what you're about to say, Pete, with that, but hopefully it's consistent with what I just said. Otherwise, I haven't learned anything in the first 4 months.
No, absolutely. So
Pete, be consistent with what he just
I
said.
will. Noted. It's funny. OC publishes its priorities for the last 5-6 years. We've published them. Historically, we hadn't. If you look at the 3 buckets which we organized our priorities in for 2017. The first bucket is protecting retail investors. So that has a number of sub-themes that I'll go through. The second 2 are seniors, and the third one is assessing risk, market risk. And so when you look at retail investors, I'm a former examiner, and so there was nothing more fun for me on an exam is to get the client files and to dig into the client files and see what the clients are being billed and where they're, what investments are being recommended to those clients, and does it make sense for their investor risk profile, and do the fees equal what's in the disclosure documents? Are the fees in what's in the investment contract with the client? I mean, digging into that stuff, and I'll give you a good example. One of the things we're focused on this year for retail investors is electronic investment advice, robo-advisors. And so about 2 months ago, I was talking to my dad right before I was given a talk. And this is my 75-year-old father, who's not a sophisticated investor. And he asked me, he said, "Have you heard of these robot advisors?" And to me, if the market's reaching him, it's hitting retail and it's hitting a lot of people. So for us, looking at electronic investment advice was very important for us to get our hands around. And particularly, here in this space, you have the mainstay firms who have robust compliance, risk, and legal departments getting into this space. But you also have startup firms who don't have a background with regulatory risk and compliance that the larger firms typically do. And so just seeing the range of compliance among those different participants, I think has been very interesting for us to work on and to focus on in 2017. I think other areas in this, I think, goes with what Jay's saying. Looking at recidivist representatives, bad actors that are in the industry that hop from firm to firm to firm, and looking to see, one, what firm procedures are in place to protect investors as they hire new firms that may have disciplinary histories. But two, also tracking those registered reps from firm to firm, so we know where they're going to ensure that they don't harm future investors, retail investors. We're also looking at exchange-traded funds. Sure, those are investment companies, typically sponsored and advised by large firms. However, looking at the sales practice, does it make sense to put, this particular senior citizen in a particularly leveraged ETF that resets daily? And looking at that decision making on an exam, that's something that we feel is very important to protect the retail investor. And so those are areas, from OC's perspective that we're focused on that I think do hit that retail investor. And I will say that, note that our priorities went out in January. Jay started in May, so OC was ahead.
No, you trained me well.
So, Peter, I wanted to pick up on something that the chairman had said earlier and ask about what your office is doing in the cybersecurity area, because we've talked about how your office is in a position to put firms on notice about what's expected, and I was interested in what you've been doing in that area, and also what are the recurring problems that you're finding with organizations who might think they have good cybersecurity systems and you're finding they don't, maybe.
Right. So 3 years ago, 2014, we were looking, cybersecurity was a huge risk when we would go in to do exams. We'd ask the leadership in each firm that we went into, you know, what keeps you up at night? What are your biggest risks? Cyber was the number one. That and the SEC coming to see them. But cyber, you know, for us, so we had to determine, you know, what is the SEC's, the exam program's role in the cyberspace? And so we initiated a 100 exam, I guess, sweep, where we looked at around 50 broker-dealers, 50 advisors. And we weren't out there looking to play gotcha. What we were looking for is to do a baseline for the industry. And so we put out a risk alert telling the industry we were going to do it. We included our request list, which we typically don't do, because we thought it would be helpful for firms as a checklist to look in their own firm to see, do I have that? Do I have that? Does this apply? And so we thought it would be very helpful to publish it, which we did. After the Cyber 1 was completed, we published our findings because we thought it was helpful for everybody to know the baseline of what small firms were doing, medium firms were doing, large firms were doing. What we saw were weaknesses, what we saw were best practices. So then we ended up, fast forward to 2015, we initiated Cybersecurity 2, the second initiative. And there we dug a little bit deeper on the IA side. We looked at some mutual funds, a few fund TAs. And then again, we had some findings which we recently published, I think it was August 7th, so a few weeks ago, where we thought it would be very helpful to put that out to the industry of what we were finding. And in this, we found things that were problematic, which we said what they were. And some examples of that were, firms would do testing and they'd have exceptions, but then they wouldn't do anything with the exceptions, or they'd run exception reports, and they wouldn't follow up on them. So that was a weakness that we saw. In terms of like terminated employees, and access controls. If someone terminated, we noticed that sometimes they never shut off their service, and we felt that was a weakness. And there were others that we included in the published document, but we also published the positives as well, the best practices, because we thought that that was helpful for the industry to look to see what other firms are doing, particularly with their size or their the different demographics that we looked at. And some of the best practices were robust policies and procedures, real testing. With mandatory training, we had seen that a lot of firms had mandatory training, which we thought was great. We noticed some, though, when folks didn't take the training, they didn't follow up. And so we thought all that information was helpful from a cyber perspective. And then what we've also done is we have the Technologies Controls Program, which is one of our 5 program areas. And that team is devoted, it's a team of ex-CISOs and cyber folks that's devoted to doing Reg SCI testing and internal control testing with regard to cyber and other access controls in the exchanges as well as Reg SCI entities, which include some ATSs. And that team we've been able to leverage on IA and broker-dealer exams because those truly are the cyber experts. And we've been fortunate enough to have that skill set in our program that we've been able to utilize them to help educate and work with our baseline examiner, particularly those that are tech savvy, to work in this space. So I do think you'll see some more work from us. Cyber 1 and Cyber 2 have been very well received. We get a lot of discussions with industry folks saying we want more because this is helping move the industry to help comply with cyber, which is a difficult issue for us. And it's a difficult issue for everyone here, personally and professionally, because a lot of times firms are victims. So.
Do you have your own hackers who test directly the quality of the cyber protections? Or feel free not to answer this if it's a sensitive question.
I think that there's some risks with, and you can read into this for the answer, but there's some risks with the federal government hacking into certain firms. And so I'll stop there.
We have no EdRock data.
No, but I mean the question obviously is, you can look at procedures in place all you want, and there's some, 19-year-old kid in wherever who can find his or her way around it, and that's the ultimate vulnerability. And the question is how one's able to test for that.
Firms employ a number of tools and technologies that they can use. And we found this in our sweep, that I think all the firms that, particularly for Cyber 2, had some sort of tools in place and technology in place to help them avoid being penetrated. But it is something that, we focus a lot on the results of their testing, the work they do in that space. I'll stop there.
So Stephanie and Steve, cyber is also a hot enforcement side issue. And I was interested you could share about what's the enforcement division doing in this area.
Sure. We're doing a lot in the area. I think, we've spent a lot of time thinking about this area for all the reasons really Pete's talked about. I think about the enforcement interest roughly, I've been saying in 3 buckets, but I actually think now I'd probably open it up to 4 buckets. And I split them up this way. First is the case, where there's a failure of a registered entity to take appropriate steps to safeguard information. That's really what Pete is talking about. So there I'm thinking about, compliance with rules like Reg SP, Reg SID, market access rule, and things like that. We have brought some cases in this space in the last couple of years. I do think, for the most part, we think about this as in the first instance, and depending on the facts and circumstances, is very appropriate for OC to be focused on and to be looking at. But there are cases, circumstances that rise to the level of enforcement action. So that's an area where we're active. The second is the bucket that I would say takes up by far the largest piece of our time, and that is cases where material non-public information is stolen because it's been hacked, or through some other cyber means, and it's taken in order to gain some sort of a market advantage, manipulate the market, insider trade on it. I would put into that bucket account intrusions, which we're seeing more and more of, and so, circumstances where an account is being hacked in order to use it to trade against another account for manipulative purposes, or to trade in order to generate some sort of a profit. And we've brought a number of cases in this space, particularly in the insider trading space using hacked information, but also in the account intrusion space. And that's an area where we really do continue to see a rise in conduct, and we are really, just continuing to put more resources into this. And then third would be cases where there's a cyber-related disclosure failure. And that's a space where we've not brought a case. But that is obviously an area of focus for us. Could envision a circumstance where a case would be appropriate, but not one where we focused, where we've brought a case so far. And then, when I say there's a 4th bucket, I think we're opening up and including within cyber, at least the way we think about it, our focus on initial coin offerings and what I'd call, loosely the Bitcoin space. And you want to address that?
Yeah, so we've spent a lot of time and attention focusing on the distributed ledger technology space. And if you don't know what distributed ledger technology is, you should go home tonight and Google it, because it's going to be important. These cases, and they've presented mostly in the context of initial coin offerings, or ICOs. They fall into 2 categories. The first category is people who they're basically scammers who are claiming to have businesses that are in the ICO or distributed ledger technology space. And as with any kind of newsworthy event, roaches kind of crawl out from the woodwork and try to scam money off investors. And, it was, when I was a prosecutor 15 years ago, it was fake cures of AIDS. And next week it's going to be Harvey relief scams. So whatever the kind of current news is. And we've seen a lot of it in the ICO space. And we've had some trading suspensions, and we have a number of investigations that have been opened of companies and individuals that claim to be in the space that really are just trying to take people's money. I think more interestingly, though, are the actual ICOs and other businesses that are engaged in using distributed ledger technology. And as you may know, the Commission issued a 21A report addressing ICOs, I guess just last month. The subject of this report was an offering by an organization called the DAO, D-A-O, not D-O-W, which is a decentralized autonomous organization, a virtual organization that exists only in computer code and executed on a blockchain or a distributed ledger. And the objective of this DAO or organization was to create and hold a pool of assets through the sale of so-called DAO tokens to investors, which would then be used to fund various projects which were to be suggested by participants in the organization. In a 1-month period last year, the DAO offered and sold 1.15 billion DAO tokens and raised in a blockchain currency called Ether the equivalent of about $150 million in value. And these DAO tokens granted their holders certain voting and ownership rights. And the report, which you can read, basically considered the facts and circumstances presented and concluded that these DAO tokens were securities, that issuers of these kinds of tokens and their equivalents had to register if those securities were going to be sold in the United States, and platforms that provided for the exchange of these tokens were broker-dealers that had to be registered and regulated. And I think in the space, in the distributed ledger space, there's been a lot of attention focused on that report. We didn't bring an enforcement action against the entity or any of its participants. But the report, sort of sends a signal as to how the Commission's going to think about these issues going forward. We have a distributed ledger technology working group. There are about 90 people across the Commission's divisions and offices who participate in this, and some of them are actually really, really smart about this space. And it's one illustration of an area that I've been particularly impressed by in the short time that I've been on the staff, of the staff's ability to try to keep out ahead of emerging products and developing technologies. So I expect that this is a space in the cyberspace that we're going to see a lot more activity.
Yeah, we live in a time of big data, and I'm sure big data has found its way to the SEC. And I think, given that, maybe start with Peter. Talk a little bit about how data analytics have changed what you've been doing.
Thanks. I would say that data analytics, I started in the exam program in 2004, and it has been a revolution in the last 5 years compared to where we were then. I would say that in almost every facet of our exam process, we are trying to digitalize what we do to be more efficient and more effective. A number of projects that we've had and have developed successfully. Probably the most significant is our National Exam Analytics tool, which we fondly refer to as NEAT. And that has, I used to analyze trade blotters using Excel and Access, and the spreadsheets the trading far exceeded what a typical spreadsheet would allow. And now we have a system in place that every examiner has access to. It runs over 50 reports. It ingests trade blotters from, you can do one firm, you can do multiple firms, and it automates all the analysis for cross-trading, principal trading, settlement, in terms of, it has a news feed that allows us to look at news events to determine whether or not there's significant trading leading up to a particular news event. It really has revolutionized the way we look at trading. We're working on text analytics projects. Two of the projects we're working on now is trying to develop a script that we would ingest a firm's compliance manual, and it would kick out what's in the compliance manual, what's typically seen in the compliance manual. It would compare it to other firms' compliance manuals, And then we would be able to identify what's missing or what's in addition. What piece of business do they have that they have policies and procedures on? From a risk scoping standpoint, while we're on an exam, that will be a pretty handy tool. Rule 204A1, Code of Ethics, in terms, there's mandatory requirements of what's included in your code. I mean, we can automate that, and we're working to do that with text analytics. We also are looking at scraping tools for firms' websites, where we can use a tool to look for sentiment language and the words guaranteed and risk-free and things like that we know are highly unlikely. And so that for us, that's a trigger. We also have automated ADV Part 2s and can run those types of searches on ADV Part 2s. We can look at 12,000 just through a series of inquiries. And so, that's something that we spent a lot of time with. We also are doing some work, our Ray team, which is a small team that basically they look at the trading of clearing broker-dealers. They get that trading, and they can analyze 300-400 firms and all the transactions that go through that trading firm, the clearing firm. And that leads to exams. It leads to potential enforcement referrals. It's a tremendous tool and work that they do on a large-scale basis, and it's 7 people. And so, we're really trying to leverage our staff using technology to get the biggest bang for our buck and get the best coverage, all the while helping investors.
Steve or Stephanie, do you want to jump in on the enforcement side? How big data is changing what you're doing?
I mean, what he said. I mean, he's really summed up a lot of the technology we use. We leverage a lot of what it is OC does, but we also use a lot of the same tools and strategies in enforcement. We have a group of quants housed within enforcement who are thinking up different ways to do all these sorts of things that Pete's described, different ways to problem solve, different ways to leverage resources, and really use data and analytics proactively in order to identify cases, but also to really use those tools to investigate, smarter, faster, more efficiently. There are lots of different places where we use it. One of the best and sort of easiest to grasp examples that we often point to are the different ways we're using data in insider trading investigations. In particular, it's been incredibly successful. All the tools have been developed in-house. Been incredibly successful at developing a variety of tools that really do, merge and analyze volumes of trading records and other data to identify patterns, patterns both among traders, among accounts, to identify and tie together sources and traders. And we've been incredibly successful at bringing all kinds of different cases in that regard. And then I'd point to a bunch of other cases. Our asset management unit has used these sorts of tools in different ways. Our complex financial instruments unit has used the tools in different ways. Think about cases we've brought involving sales of structured product to retail investors. Some of those cases have been sourced using data analytics. Churning cases, we've brought a couple and have some others in the pipeline. Think about cases like cherry picking schemes and other things like that. Those are all identified or are often identified through the use of data analytics. So it really does do the work as Pete described, does the work of just many people that would normally take, eons to do in a very short compressed time frame. And the cases are very compelling on the data, and oftentimes what we've been doing in enforcement when we have this sort of data pulled together is taking it out to firms and laying it out. And rather than do investigations regular way and send subpoenas for all kinds of documents, we will often sort of do what we call a day one reverse proffer and sit down and say, this is what the data show. Help me understand it. And sometimes we're not understanding it right, and sometimes we're understanding it exactly right. And so it's really shortcut our investigations.
Look, I would add this, and it's been an impressive thing for me to see how the commission is using this. Markets are supposed to make sense, and when you see anomalies in the market, it's probably a place where we should look further, whether it's in the way a firm operates or a particular type of trading. And the use of big data to identify those anomalies has really helped us, because we can say, hey, and I get the reports, and there is a 1 in 1 billion chance that these 5 people would have traded together in those 7 stocks on these 6 days. That tells you something, and you really don't need to look much farther. And 10 years ago, you wouldn't have had that type of analytics. Same thing in the inspection space. And if I could just go back to the cyber, the 4 buckets Stephanie talked about, and Pete talking about, our proactive efforts with exchanges, custodians, broker-dealers, and investment advisors, people at the heart of the day-to-day activities in the securities markets. I think that's what, at least I hope that's what the person on the street would want us to be doing in the cyber area.